we venture into understanding the law of succession. Welcome on board wherever you are. 22914 is my SMS number, Facebook page Mwangaza TV, and YouTube channel Mwangaza TV Kenya. Join us even as we get engaged.
Thank you, Celestine, for another chance for us to continue educating our viewers. Today, as you've indicated, we are going to discuss what we know as succession or inheritance. Succession is governed by a law called the Law of Succession Act. And when we talk about succession, it is what happens to the estate of the deceased once they are no more. What will happen to what they have worked for? They have worked for land, they have money, or they have any other kind of movable or immovable properties. How will these properties devolve to their beneficiaries? That is what we can describe as succession.
So maybe Mr. Lewis, talk about the different types of will, and especially those that are identified under the law of Kenya.
Thank you. We've talked about two types of succession. Let's start with the first one. When someone dies having written a will, I would say this is the best form of devolving your estate or your properties, because this will enable you to give whatever you want to whomever you want, so that it is not necessarily family members. You can write anyone on the will. You can give someone a property on your will, even if they are not your dependents. I would continue to say that if you wish to write a will, it is proper that you visit a lawyer or an advocate, because we also have, and maybe we'll discuss that some other time, the form of a legally valid will. There is how it should be drafted, there is what it should contain, so that it does not end up being charged in court. Something else I would want to mention on that aspect is that you can write as many wills as you would wish. You can write a will today, tomorrow you acquire some other properties, then you need to update that will. What usually happens, and that is why I advise it's good to visit a lawyer, is that you cancel your former will and write an updated will. So people should not be afraid that writing a will, there are some people who say that you are inviting death.
About to die.
Yes, those are just myths. It's good to have a will, because it will allow you to distribute your hard-earned properties and assets to whomever you would want to leave it to. Yes.
There are times when people don't really write down their wills, but someone can just speak it orally, say, you know what, I'm giving you this, I'm giving you this. Is this also acceptable under the law of Kenya?
Thank you. And that is why I indicated one day we will have a topic to discuss more about the wills. We have what we call oral wills, and we have the written will. The law provides that if you make an oral will, because there are some instances where you can make an oral will. For example, the law allows soldiers just before they go to war to just make their wishes known, maybe for the assumption that they can die during the war. So there are instances where an oral will can be valid, and one instance is when you die within 3 months after making that oral will. However, due to the requirement of witnesses and that can be charged, it is always advisable to have a written will. And that is why I indicated that you can visit a lawyer who will help you draft the will according to the rules required of that will. It can be deposited with a lawyer, and there will be a requirement, as we shall discuss some other time, of 2 witnesses who are not beneficiaries to the will. They can also keep their copy, so that in the event of death, and there is a dispute as to whether that will was made by the deceased or not, there are several copies available. One which is with the lawyer, and the witnesses who signed might have kept their copy. So if there is such a dispute, these copies can be compared to show that it is a valid will. Yes.
What are the rules that are considered when it comes to the distribution of the deceased's property?
Thank you, Celestine. There are some rules provided under the Law of Succession Act. One is who can be a beneficiary. And there is a hierarchy provided by the Act. Number 1 hierarchy is the wife or the surviving spouse and the children. If we do not have the surviving spouse and the children, then we can go to the next level, the parents of the deceased. Then on and on and on, the law have provided a hierarchy. And if there is no one at all related to the deceased, there is no one who is in that hierarchy, either a parent, either an uncle, then the property can devolve to the government. So there is that hierarchy provided by the Act. However, the law allows anyone to challenge if they feel they have been left out in the will. And that is why there is a requirement for gazettement once you file that petition, so that if anyone wants to protest, maybe, for example, saying they are children of the deceased, whether born out of wedlock or not, they can be able to challenge. Whether they are indicating they are former spouses, anyone who feels they have a ground to be included in the distribution, they are allowed by the court to protest. And then the court will hear the protest, and if it is valid enough, they will be included in the mode of distribution.
You've talked about a gift. Anyone who gives out something without drafting it, and when he or she is still alive, is considered to be a gift. Is there a time when a gift can be contested in court of law?
All right. That is a very good question. Number 1, if someone happens to give you a property or a gift, let's talk about land.
Yes.
And they die before registration, or what we call transfer of that land to your name, that property will still be governed under the Law of Succession Act. Any property that still remains in the name of the deceased will have to be passed through the provisions of the Law of Succession Act. As to whether all the beneficiaries will agree that this property, even though not transferred, had been given to so and so, that is another question. But if they agree, but any property that is still in the name of the deceased, as at when they die, will have to be distributed in terms of the rules provided by the law.
Unatazama Mwangaza TV, tumaini lako.
Kama wakati mmoja kulikuwa na ukame sana, tulikuwa tunakula ugali ya namba 2 na supu ya nyanya.
Nikasomewa ulifoji receipt ya Embakasi Ranching, kasema hapana, sikufoji, nikapelekwa rumande. Na mimi ni mchungaji.
Licha ya kuwa nilikuwa napika chang'aa, hata wale nilikuwa na wanywesha asubuhi wakienda shule chang'aa. Watoto wangu. Kifugo ya shetani haina msamaha, haina huruma, unaenda kafukafu, tena ni ya madharau.
Unatembea kama umeinama.
Ni kama kalori kamekata center borot. Naendaga hivi. Na mdomo kuna vile ilikuwa ina hang kwa sababu ya kuweka gum kwa mdomo.
Babako alikuwa kipofu.
Yes, alikuwa kipofu kabisa. So anajua hiyo ni rebus, hiyo ni explainer.
So aliwalea na hiyo kuhubiri kwa mabasi.
Sadaka.
Kuitwa ni kitu moja. Hapo katikati. Hapo katikati utakutana na challenge. Ile kitu inaweza kumsaidia ni kuwa muombezi.
Fuata vile Roho wa Bwana anakuambia.
Nikaona katika matatizo ile mtu anapitia, ni vyema kuelewa ya kwamba si Mungu amekudharau.
Haini naongea na wewe, naweza shuhudia utukufu wa Mungu ndani ya maisha yangu. So jipe moyo.
Siku moja
Ilichukua tu dakika kukiri Yesu ni Bwana.
Mambo yote yakaisha.
Mambo yote. Mimi sina alama nyingine isipokuwa hii. Na nilisema sitaweka jino hii ili niwe naibisha shetani.
Kwa hivyo ujitie moyo na ulitie jina la Mungu, kwa sababu hilo jina liko.
Kwa hayo yote ungana nami Kelvin Kariba kila siku ya Jumanne zinapotimia saa 1:45.
Some of the considerations and the lay down procedures, especially when one wants to write a will.
Thank you. Let's start as again we said we have two forms of succession.
Yeah.
I know recently we have other forms of the way someone can distribute their properties, and maybe we shall discuss that another day, things like family trust and all that. But for today, let's focus on the two. When someone wants to write a will, as I advised, it's good to visit a lawyer, because there are parameters, or there are things or criteria that a valid will should adopt. And so that you don't make that mistake and have a will that cannot be enforceable, it is always advisable to visit a legal expert. So a will be drafted, and it will be, again, as we said, attested by two persons who are not beneficiaries. And then it will be, of course, registered and stored. In case of death, then there is someone who is named on that will that we call an executor. The deceased nominates someone who will execute his wishes, who will ensure that his wishes are adhered to. And that is a person we call an executor. So in case of death, this executor will petition the court for grant of probate with a will annexed. They will, of course, draft a petition, attach the will, so that that will can be recognized by the court. And once the will is recognized, then the estate will be distributed as per the will. However, let's say at the point of filing this petition for grant of probate, someone contests that will, because it is allowed that someone can contest a will. For example, saying it is not a valid will, it is a forgery, it is fraud, and such things. The court will consider all those protests and then give it a verdict. We have also talked about the other form, intestate succession. When someone dies having not made a will, the people we are calling administrators, among the beneficiaries, they will appoint some administrators who will, of course, through the guidance of a legal expert, petition the court for what we call letters of administration. The court will give them letters of administration, or rather what we would call authority to deal with the estate prior to distribution. We talked about payment of debts, correction of revenues, and such kind of things, just to ensure that the estate is not wasted. So again, through the guidance of legal experts, there will be gazettement, and then after 6 months, assuming there is no dispute, there will be what we call petitioning for a confirmation of grant. It usually have something attached that we call affidavit of mode of distribution, where we will state all the estates that were left by the deceased, and then we will also state all the beneficiaries and how they wish to distribute the estate. And then the court, if there is no dispute, will confirm that grant and give authority for the distribution of the estate.
There are times when all witnesses have died, and the person who wrote the will has also died. Now, maybe by the time the deceased passes on, he had not updated his will. What happens in such cases?
Thank you for that. That's a very pertinent question, even though it touches a lot on what I would want us to discuss another day, the component of a valid will. But let me touch on that question, because the components are many. But let's assume the witnesses dies. It is advisable, and that is why, again, we said it's good to seek a legal expert or enlighten the will. It's advisable that if the witnesses dies, you update that will. You can maintain the same content other than the witnesses that you have changed. Because one of the difficulties would be if that will is charged, we might not have witnesses who are saying, I was there, it was written by the deceased, I witnessed, and these were his wishes. So it's always good that if the witnesses dies before you, you update that will. However, remember we said that it's good to register the will, and it's also good to keep a copy either with a law firm, or some people even keep these copies with banks or institutions, just to secure that it is safe, so that by the time it is presented to court, the issues of fraud, the issues of forgery would reduce if the will was properly documented, properly stored or registered to prevent such disputes. However, it is good to ensure that you keep updating the will.
Help us understand, when a will has been contested, what are the legal avenues available in the law of Kenya?
Thank you. I will start by saying that people fear succession. And I would start by saying, if there is no dispute, succession is not a case. It is a process. You are just required to go to court, file the petition, get the administrators, get the mode of distribution, and the court gives you what we call a confirmed grant. However, if there is a dispute, sometimes we find cases or petitions dragging in court for years, just because there is a dispute. So, first of all, I would advise any family, if you happen to, your loved ones be deceased, it is always good to agree before you go to court. Sit down, agree, how are we going to distribute this estate, so that it becomes a process and not a case. However, the law provides and gives rights to anyone who wishes to protest the mode of distribution presented by the administrators. They can file their protest. If the beneficiaries are in disagreement, the court will require each party to file the affidavit and submissions of the stating their side of the story and why they think a certain way should be followed, and then we would leave it to the court. The court will make its own determination on the mode of distribution, which then will be binding. So the reason why I advise families it's always good to agree is because once the court is seized of the matter and there is a dispute, the determination whether it favors you or not will be binding. Succession is not a case, it's a process.
Okay.
If you agree, the court will never interfere. It will just sign everything you've agreed. And that is the general rule. Once you file the succession, the petition, the court will request you for the mode of distribution. Once everyone has signed, the court will just approve. So if you don't agree, that is where now the court comes in to make its own determination. And that is why at the very end, ile yenye tunaitanga confirmation of grant, every beneficiary must come to court.
Thank you so much, Lawyer Lewis, for that insightful engagement. It has been a great education so far. I've learned so much, and I hope that you, my viewer, has actually learned more than me. In case you've missed out on the other episodes, we tackle different legal issues. Kindly follow us on our YouTube channel, Mwangaza TV Kenya. Next week, we'll be tackling a different issue, all the same, maybe with the same or a different lawyer. Just make sure that you're joining us every Monday, 7:30 p.m. Till next time, I'm Celestine Waka the Favored.